The document on the table in front of me was not the one Preston's father's attorney had drafted. I knew this because I had drafted the one on the table in front of me, and I had been drafting documents for 11 years, and you develop a relationship with your own work, the particular rhythm of your clauses, the way you place a definition to do work 3 paragraphs later. The folder was ivory, the kind used for closing documents and wedding ceremonies, and I was sitting in the anteroom of St. Philip's in a dress that had cost more than my first car, and outside the door I could hear the organ warming up, and the document in front of me was exactly what I needed it to be. I closed the folder. I had 14 minutes. The dinner had been in March. My mother had set the table herself, which was the first signal. Shelley Wilson did not set tables for ordinary dinners. She directed their setting, adjusted the centerpiece, and took credit for the result. When she said it herself, you were about to be managed. The china was the Limoges. The candles were lit before we sat down. My father came in from his study with the look he wore when he'd rehearsed something. He had the patrician bearing of a man who had inherited everything he appeared to have earned, and it had served him for 61 years, and I could see that evening that it was beginning to cost him effort. The bearing was the same. The effort was new. We ate the first course. My mother asked about my firm. I described a transaction in general terms. My father nodded with the performance of a man absorbing information he did not intend to retain. The wine was the good Burgundy, which was the second signal. He said, "I want to talk to you about the company." I said, "All right." He laid it out with what I recognized as his approximation of legal precision: the secured creditor, the note, the 3-month horizon, the cascade risk. He was not wrong about any of it. He had never been wrong about the shape of the problem. His talent was for failing to understand that knowing the shape of a problem and having caused the problem were not mutually exclusive conditions. My mother said, "Preston Thompson is an exceptional young man." She said it the way you introduce the solution to the problem you have just finished presenting. I picked up my wine glass. I said, "How is the acquisition structured?" My father said it was a merger, strategic partnership. The Thompson family had been looking for a manufacturing component to round out their portfolio, and Wilson's textile IP was, he used the word distinctive. I noted the word. I said, "What are the contingency terms?" There was a pause. My mother looked at her plate and back up. My father said that the Thompson family had expressed a preference for the transaction to be accompanied by. He used the phrase an alignment of family interests. He said Preston and I had met twice at charity events, and that Preston had expressed genuine regard. I looked at my father for a moment, then at my mother. I said, "I'll need to review the terms." My father's shoulders dropped a 1/4 inch. My mother reached across the table and covered my hand with hers. She said, "We knew you'd understand." She had misread a procedural statement as emotional capitulation, which was a habit of hers, and which had never once served her well in dealings with me, and which I had stopped correcting years ago. I finished my wine. I helped clear the plates. I drove home on the bridge over the Ashley River, and the water below was black, and the city lights ran across it, and I called Diana before I had taken off my coat. She said, "How did they present it?" I said, "The way they present everything, as though the decision had already been made and I was being invited to participate retroactively." She said, "And the Thompson terms, did they give you documents?" I said, "Tomorrow, but I've already seen the framework. His father's attorney filed the acquisition intent with the state 3 weeks ago. I pulled it Thursday." There was a pause. Deanna said, "So." I said, "So we moved to phase 3. I had started reading the company's books at 19. This was not because I was precocious or suspicious. It was because my grandmother, Vera Wilson, had handed me the quarterly statements one summer with the instruction to tell her what I saw. She was 81 and her eyes were failing, and she trusted no one in the family with numbers except me. I told her what I saw. She nodded. She said, "Your father has been borrowing from the left pocket to fill the right one for 6 years. He will eventually run out of pockets." She was correct. It took another decade, but she was correct. When she died 3 years ago, she left the disposition of her personal shareholding to her estate, administered by her attorney, with instructions I had been a party to drafting. My parents had been present at the will reading. They had not been present at the subsequent 14 months of quiet, legally unremarkable transfers that had moved Vera's shares through the estate in increments that required their signatures on documents they reviewed for an average of 40 seconds each. I did not feel guilty about this. Vera had wanted it done this way. She had said, "They will not fight what they do not understand has happened until it is too late to fight it." She had said this without bitterness. She simply knew her son. My consolidated position was 31%, not a majority. Enough. Diana had identified the Greenville company, Hartwell Industrial Holdings, in October. I had met with their principal twice, once in Columbia and once at a conference in Atlanta, where neither of us had appeared to know the other. They wanted the textile IP and the client contracts. They had no interest in the Wilson name. They were willing to pay what the assets were worth, retain 70% of the workforce, and close within 60 days of a clean title transfer. There was no marriage contingency. The prenuptial agreement Diana and I had spent 6 weeks drafting was 43 pages. It was not the document Preston's family's attorney had prepared. It had been structured so that its execution would place my minority interest into a protected trust, establish my standing as a party in any acquisition challenge, and trigger Hartwell's standing offer. It was, technically, a prenuptial agreement. It was also the closing instrument of a 14-month restructuring that no one in my family had seen coming, because no one in my family had ever fully understood what I did for a living. I had explained it to Aunt Margaret in January in her house on Sullivan's Island over 2 hours and a pot of coffee. She had listened without interrupting, which is one of the things I had always valued about her. When I finished, she was quiet for a moment. She said, "Your father will not forgive this." I said, "No." She said, "And Shelley." I thought about my mother, the Limoges china, the rehearsed warmth, the hand over mine at the dinner table. I said, "She'll forgive me when she understands what I preserved." I paused, "Or she won't." Margaret had a dormant board seat from the original 1941 family charter, a provision no one had bothered to formally extinguish, because no one had imagined she would ever use it, because no one had imagined she would ever be invited back into a room where it mattered. I had read the original charter 4 years ago. I had made a note. She said she would be at the wedding. I found the transfer documents in my father's desk in April. I was looking for my grandmother's original share certificates, the physical documents, which I needed for the trust filing. I had asked my father for them twice and been told they were in the house somewhere, which was the answer he gave to any question whose answer required effort to locate. I drove to my parents' house on a Tuesday afternoon when I knew they were at the club, and I went into his study, and I found the certificates in the second drawer. Under them was a manila folder. It was labeled in my father's handwriting, "Vera Estate Advance." I stood at his desk in the afternoon light, and I opened it. What it contained was a transfer record, 2 years old, notarized, showing the movement of $340,000 from my grandmother's personal accounts into Wilson Manufacturing's operating fund. It had been structured as a loan. There was no repayment schedule. There was no board approval. Vera had been 82 at the time, and her signature on the authorization was a version of her handwriting I recognized from the last year of her life, when her hand had started to fail. I stood there for a long time. I took photographs of every page. I put the folder back exactly as I had found it. I put the share certificates in my bag. I let myself out of the house, and I sat in my car in the driveway for a few minutes, and then I drove to the Battery and I walked along the water for 40 minutes. And it was a warm April day, the kind Charleston does in spring before the heat settles in for good, and the harbor was bright and full of movement, and I thought about my grandmother's hands in the last year of her life. I did not call Diana that afternoon. I drove home. I made dinner. I sat at my kitchen table in the early evening and I thought about Vera handing me those quarterly statements when I was 19 and saying, "Tell me what you see." I thought about what she had seen in the years before that and what she had chosen not to say to her son and what that had cost her. I was in the bathroom when I cried, briefly, and then I washed my face and went to my desk and called Diana at 8 o'clock. I said, "The character of the estate transfer has changed." She understood immediately. She said, "That's not a loan, that's conversion." I said, "That's what I thought." She said, "This changes your standing considerably." I said, "Yes, I know. I've already updated the language in Section 12. The wedding preparations were pleasant. This is not sarcasm. My mother in full social production is a remarkable thing to observe. She moved through the months between April and June with the focused efficiency of a woman who had been waiting her entire life for an occasion worthy of her organizational gifts, and the wedding of her only daughter to a Thompson was that occasion. I attended the fittings. I approved the flowers. I sat across from Preston at the rehearsal dinner, and I listened to him talk about his family's portfolio and his plans for the textile division, and I responded with sufficient interest that he relaxed and talked more, and I noted what he revealed and what he didn't. Preston was not cruel. I want to be clear about this. He was a man who had moved through the world on the assumption that the world was organized for his comfort, and this assumption had been so consistently validated that it had calcified into something he experienced as simple reality. He did not know what his father had inserted into the acquisition terms, or if he suspected, he had the wealthy man's talent for not examining the mechanisms of his own good fortune. He was not unkind to me. He was simply a man who had never read a room the way I read rooms. At the rehearsal dinner, he said, "You seem very calm about all of this." I said, "I'm a transactional attorney. I find closings clarifying." He smiled. He thought I was being wry. I was being precise. Diana did not come to the rehearsal dinner. She did not come to the morning of breakfast at my parents' house, which Shelley had organized with the seriousness of a state occasion. Diana was in her office in Columbia, which was where she needed to be. We had spoken at 10 the previous night and confirmed every element. She said, "The Hartwell representative will arrive at the venue at 9. He'll stay in the anteroom until you need him." She said, "Margaret has confirmed." She said, "The documents are as we reviewed them." I said, "Good." She said, "Madison," a pause, "this is going to hold." I said, "I know, I drafted it." She made a sound that was almost a laugh. She said, "Get some sleep." I did not get much sleep. I lay in my childhood bedroom. I had stayed at my parents' house the night before because my mother had asked, and I had no reason to deny her the gesture. And I looked at the ceiling, and I thought about the texture of closing days. The particular quality of the hours before a transaction completes, when everything is in place, and the only remaining variable is execution. I had sat in closing rooms at 2 in the morning with bankers, and opposing counsel and coffee gone cold, and I had learned that the feeling that arrives just before the wire transfers, the feeling that is not quite anticipation and not quite calm, was something you could trust. It meant the work was done. The church was full by 10:30. I stood in the anteroom with my bouquet, white peonies, because my mother had chosen them and I had not objected, and I thought about the folder in my father's desk. The handwriting on the tab, Vera, estate advance. I thought about what the word advance had been asked to do in that sentence, and how much weight a single word could be made to carry when the person writing it needed not to name the thing directly. The Hartwell representative, a compact, careful man named Ellis who I had met twice and trusted completely, was standing near the window with his briefcase. He looked at me when I came in. I nodded. He nodded. Margaret arrived at 9:45. She came into the anteroom before taking her seat, and she held my face in her hands for a moment and looked at me and said nothing, which was correct. There was nothing to say. She went out and sat in the third row on the left side, which was where I had told her to sit. Because from the third row on the left, she would have a clear line of sight to the signing table, and she could stand without disrupting the row in front of her. My father came to the anteroom at 10. He was in his morning coat and he looked, for a moment, genuinely moved, and I understood that this was not performance. He loved me, in the way that people love what they have staked their future on. I did not return the hug briefly. I held it for a moment. He smelled like the same aftershave he had worn my entire life. He said, "Ready?" I said, "Yes." We walked into the organ and the standing guests, and the light through St. Philip's tall windows, which was the particular pewter and gold of a June morning. And Preston stood at the front and looked at me with an expression that was genuine enough. And my mother was in the front row with her eyes already bright, and I walked the length of the aisle with my father's hand on mine. The officiant was efficient. The vows, the preliminary portion, the reading, the opening remarks, took 11 minutes. Then he said what he always said at this juncture in a South Carolina ceremony, that before the exchange of vows, the parties would execute the prenuptial agreement as previously arranged and witnessed. Preston's family's attorney, a broad man named Holcomb, who I had observed at 2 prior social occasions and assessed accurately both times, came forward with his folder. I said, "I have the documents." Holcomb stopped. He looked at Preston. Preston looked at me. I placed Diana's folder on the signing table. Holcomb opened it. He read the first page. I watched his face do the thing that faces do when they encounter language that is not what they prepared for, a slight tightening, a recalibration, the rapid pivot of a man determining how much he understands of what he is reading. He said, "I'll need a moment to review this." I said, "Of course." I said, "I should mention that the Hartwell Industrial Holdings representative is in the anteroom. Their standing offer on the Wilson manufacturing assets expires at noon." The church was quiet the way churches are quiet, not silent, but held. Preston said, "What is Hartwell Industrial?" I said, "The alternative acquirer. Their terms are in the exhibit beginning on page 19. He took the document from Holcomb. He read. He was a faster reader than I had expected, which I noted and filed. Holcomb said, "This would require a full recess. We cannot execute this in the current." I said, "The trust provision is self-executing upon signature. The Hartwell offer is time-sensitive. The board seat activation requires only Margaret Wilson's presence and acknowledgement, which she can provide from her current seat." I turned, just slightly, toward the 3rd row. Margaret stood. She did not speak. She simply stood, and the people in the rows near her turned to look, and my father in the front row turned, and he saw her, and something moved through his face that I had never seen there before, not anger, not grief, something older than both. Recognition, maybe. The recognition of a man who has managed a situation for 20 years and is watching the management come undone from a direction he never looked. My mother's hand went to her throat. She was wearing her pearls, the ones that had been Vera's. She looked at me. I held her gaze for a moment. I did not look away, and I did not explain myself, and I did not offer her anything to hold on to, because there was nothing I could offer that would have been true. What she saw in my face, I don't know what she saw. I know what I felt. I felt the particular clarity of a thing completed, and underneath it something that was not triumph and was not grief, and did not have a name I was willing to use. I turned back to the table. I said, "Shall we proceed?" The legal outcomes settled over the following 6 weeks. Hartwell closed on the Wilson manufacturing assets at fair valuation. The workforce was largely retained. The textile IP transferred intact. The Wilson name was attached to a subsidiary designation that would survive in reduced form, which was more than the Thompson acquisition would have preserved. My parents did not contest the Hartwell terms. I think my father understood, by the time Holcomb had read to page 22, that contesting them would require examining the estate transfer, and he was not prepared to do that in a forum where the documents existed. Preston and I did not exchange vows. He called me 3 weeks later. The conversation was brief and professional and contained no recrimination, which I had not expected and which I thought well of him for. He said he had read the Thompson Capital internal memo after the fact. He said, "I didn't know about the marriage condition." I said, "I believe you." There was a pause. He said, "You were always going to do this." I said, "I was always going to do this the right way. There's a distinction." He was quiet for a moment, and then he said yes, and that was the end of it. My mother called on a Sunday in July. The conversation was shorter than I expected. She said she needed time. I said I understood. She said, "I don't know how to," and stopped, and I waited, and she did not finish the sentence. I said, I know, I said. I'm not going anywhere. I let that be the whole of what I offered. It was honest and it was incomplete and it was what I had. My father did not call. The apartment on Rutledge had good light in the mornings. I had chosen it for the light and the distance from my parents' house, and the fact that it was mine, my name on the lease, my furniture chosen for no reason except that I wanted it, my kitchen organized according to no logic but my own. I was at my desk on a Tuesday morning in August, 6 weeks after the wedding that had not been a wedding, working on a restructuring agreement for a client in Greenville. The window was open, and the street sounds came up from below, the particular texture of a Charleston summer morning, the heat already present at 8 o'clock, the city going about its business in the way that cities do, indifferent and continuous. The Vera Wilson Charitable Trust documents were in a folder at the edge of my desk. They had been finalized the week before. The estate conversion claim had been settled quietly, and the settlement had funded the trust, which would disperse to 3 organizations Vera had supported in her lifetime. Diana had done the final filing. I had signed as trustee. I picked up my pen. The light came through the window and lay across the desk in a stripe, and my hands were in it, and I began to write.